This is a Fox News alert. We want to go quickly inside the courtroom where that young woman you see on the screen, her name is Michelle Carter, stands accused of involuntary manslaughter for sending hundreds of text messages to her boyfriend, urging him to kill himself. He did. And now the judge, there is no jury in this case. She waived her right to a jury. The judge, Lawrence Moniz, is reading his decision. Let's listen.
There is a duty to take reasonable steps to alleviate the risk. The reckless failure to fulfill this duty can result in a charge of manslaughter. Knowing that Mr. Roy is in the truck, knowing the condition of the truck, knowing, or at least having a state of mind, that 15 minutes would pass, Ms. Carter takes no action in the furtherance of the duty that she has created by instructing Mr. Roy to get back into the truck. She admits in a subsequent text that she did nothing. She did not call the police or Mr. Roy's family. She knew his location, again, according to a text that she sent, as being at the Kmart Plaza. According to one of her emails and other credible evidence, according to other credible evidence, the police officers who testified, the location where Mr. Roy's truck was located was approximately 1/2 mile from the Public Services Office of Fairhaven, which included both the fire department and the police department. She did not notify his mother or his sister, even though just several days before that, she had requested their phone numbers from Mr. Roy and had obtained them, and had opened a line of communication with Camden Roy on, I believe, July 10th, but just a few days before the events in question. She called no one. And finally, she did not issue a simple additional instruction: get out of the truck. Consequently, this court has found that the Commonwealth has proven beyond a reasonable doubt that Ms. Carter's actions, and also her failure to act, where she had a self-created duty to Mr. Roy since she had put him into that toxic environment, constituted each and all wanton and reckless conduct. And this court further finds that the Commonwealth has proven beyond a reasonable doubt that said conduct caused the death of Mr. Roy. This court does not find that the intentionality necessary for such wanton and reckless conduct is obviated by Dr. Bregan's theory of involuntary intoxication, in that the court did not find that analysis credible. Ms. Carter, please stand. This court, having reviewed the evidence and applied the law thereto, now finds you guilty on the indictment charging you with the involuntary manslaughter of the person Conrad Roy III. This court further finds that the Commonwealth has proven beyond a reasonable doubt that you are a youthful offender and you are a judge so at this time. You may be seated. That verdict is now recorded and it is in writing as well. Commonwealth, do you wish to be heard? Pardon me? The Commonwealth moves for sentencing. Sentencing is not appropriate at this time. Chapter 119, Section 58 requires that a pre-sentencing report be prepared and given to the judge before sentencing can be imposed. Understood, Your Honor. With that, the Commonwealth would ask the
Well, the judge, in a rather stunning decision, has found this young woman, Michelle Carter, guilty. She sent a myriad of text messages to her boyfriend encouraging him to kill himself. He had strung a pipe affixed with carbon monoxide into his truck and he sat there and he died. Her messages to him right beforehand were, "Get back in your truck." Another one, "I thought you wanted to do this, just do it." And so even though there is no crime in the state of Massachusetts that criminalizes assisted suicide, there is involuntary manslaughter, which is reckless behavior causing somebody else's death, and the judge so found. Let's go to Molly Lyons, standing by live outside the courthouse in Massachusetts. So, Molly, it was a strategic decision not to use a jury. She waived it, thought maybe that the judge would construe the law in her favor. He did not.
Yeah, one of the theories behind that decision was that it would take some of the emotion out of this trial that could have been played out before a big trial with a large jury. And in fact, the judge did at many times during the trial actually say, you know what, we don't need to play that in open court. I'll take a look at it later in chambers. I'll review all of this evidence. So in a sense, it did speed the trial and push it forward. Now he has made his determination of guilty. And one of the things that he kept hammering in on as he was explaining how he reached that decision was wanton and reckless behavior. Ms. Carter was accused of involuntary manslaughter, and that was a key part of this case. She had to know what she was doing and press forward. And he makes the argument, the Judge Lawrence Moniz, who this was all put into his hands, he makes the argument that she knew what she was doing, her actions created the situation, and there was a particularly key point, a key text throughout the course of this trial that he referred to when he said she acknowledged later that she knew of her actions. That was a text between herself and a friend of hers, a friend named Sam, in which months later she acknowledged to her friend Sam what she believed she had done. This is the text. She says in this text, "Sam, his death is my fault. Like, honestly, I could have stopped him. I was on the phone with him, and he got out of the car because it was working, and he got scared, and I, expletive, told him to get back in, Sam, because I knew he would do it all over again the next day, and I couldn't have him live the way he was living anymore. I couldn't do it, and I wouldn't let him." Now, prosecutors really hammered home on that point, that at the final moments of his life, when Conrad Roy reached out to Michelle Carter, she told him, in essence, to get back in the vehicle. And the judge argues that she understood the toxic environment of that vehicle. And throughout the course of the trial, prosecutors made the argument that she actually helped him create that toxic environment, offering suggestions. And that, in fact, towards the end of his life, in the days prior to him actually committing suicide, that she mocked him when he put things off. On the actual day of his death, here's an exchange between the two, between Michelle Carter and Conrad Roy. She says, "You can't think about it. You just have to do it. You said you were going to do it. Like, I don't get why you aren't." He replies, "I don't get it either. I don't know. So I guess you aren't going to do it then. All that for nothing. I'm just confused. Like you were so ready and determined." He replies, "I am going to eventually. I really don't know what I'm waiting for, but I have everything lined up." Later in the day, she actually asked Roy to promise that he would do it that day. He did. She told him, "You can't break a promise," and she actually suggested at that point finding a quiet parking lot. That, of course, is exactly what we know he did.
This court first finds that the Commonwealth has proven beyond a reasonable doubt that the actions taken by Ms. Carter as to the period from June 30th to July 12th constituted wanton and reckless conduct by her in disregard and serious disregard of the well-being of Mr. Roy. The Commonwealth has not proven as to that time period that said reckless or wanton behavior caused the death of Mr. Roy. It is apparent to this court in reviewing the evidence that Mr. Roy was struggling with his issues and seeing a way to address them, and took significant actions of his own toward that end. His research was extensive. He spoke of it continually. He secured the generator. He secured the water pump. He researched how to fix the generator. He located his vehicle in an unnoticeable area and commenced his attempt by starting the pump. When Ms. Carter realizes that Mr. Roy has exited the truck, she instructs him to get back into the truck, which she has reason to know is or is becoming a toxic environment inconsistent with human life. She is mindful that the process in the truck will take approximately 15 minutes. This court finds that instructing Mr. Roy to get back in the truck constituted willful and wanton and reckless conduct by Ms. Carter, creating a situation where there is a high degree of likelihood that substantial harm would result to Mr. Roy. Ms. Carter knows, through her own admission, that Mr. Roy has followed her instruction. As she indicates in various text messages subsequently created to some of her friends, she indicates that she can hear him coughing and she can hear the loud noise of the motor. Consequently, this court has found that the Commonwealth has proven beyond a reasonable doubt that Ms. Carter's actions and also her failure to act, where she had a self-created duty to Mr. Roy since she had put him into that toxic environment, constituted each and all wanton and reckless conduct. And this court further finds that the Commonwealth has proven beyond a reasonable doubt that said conduct caused the death of Mr. Roy. Having reviewed the evidence and applied the law thereto, now finds you guilty on the indictment charging you with the involuntary manslaughter of the person Conrad Roy III. This court further finds that the Commonwealth has proven beyond a reasonable doubt that you are a youthful offender and you are a judge sole at this time. You may be seated. That verdict is now recorded and it is in writing as well.